the import of this order, because it is said it freezes all the business that lawyers are conducting. So there's no advocate then who can say that they were not aware of these orders. I was just checking whether Mr. Kamotho, who I normally follow on social media, whether he commented, but unfortunately he did not comment on this order. So basically, there's no need for a formal application to bring this order to the attention of the court, even as we got it just the other day. And it is upon us as officers of the court to bring this important information before the court so that the court can see where we lie. In fact, I'm being informed, the Law Society of Kenya even sent an email to all its members, including ourselves, including the ones that are before you, on the import of this order. Lastly, on the suggestion that the order only applies to services procured post the order, that's not correct. My Lord, I have no doubt that when you look at this order, you'll be able to see the wide terms in which it is framed. It talks even suspending the engagement, then procuring. So procuring and engagement are totally different. So Mr. Mongela is engaging with a public body. Those are two terms in this order. Continuing to procure, even continuation. Even pending payments, Mr. Mongela will not be paid. All engagements of private advocates, including coming to be able to attend this matter, where there is already hired an attorney general, state councils, and goes on, and the county government. In fact, my Lord, the Association of County Attorneys issued a very strongly worded statement on this because it more or less freezes their business. We have people, I know the Law Society is seeking to vary or set aside this order, but as far as until it is varied or lifted, there's still that challenge. So, my Lord, we humbly seek your directions on this so that then we conduct proceedings that do not violate another court order of a different court. And that's all, my Lord, from me, Mr. Nagwe.
My Lord Devanjiri, just to add on one thing that Council has failed to address, the question that has been raised by Mr. Mongela on the right to be heard. My Lord, the judge who issued this order was alive to that fact. And that is why he's saying that the only persons who are barred from appearing and representing public bodies are private advocates stroke law firms. Then he goes ahead and says, when there is already an hired attorney general, state councils, solicitor general, and the county attorneys. So he's alive to the fact that such an order may create an hindrance to the access to justice under Article 50. But he then says, even when an order such as this has been issued, there is another body providing similar services. So Mr. Mongela cannot say that his client will be prejudiced and the right to a fair trial under Article 50 will be compromised because there is already an existing alternative.
Okay. Counsel, you know. What you've done is you really argued an application which is not before me yet. That's essentially what you've done. So the direction is very simple. I've just had a quick look at the order, and I think item E in the order is the one that you are referring to.
Yes, Your
Item
Lordship.
E.
Yes, Your Lordship.
First of all, I'm not sure myself I even understand the order, where it says a conservatory order is issued suspending the engagement procuring, continuing to procure, pending payments. I don't know how fits in. All engagements of private advocates or law firms by public entities when there is already hired Attorney General. Hired by who? There's a whole question of interpretation here. Can you please file a form? This is the direction I'm giving. Petitioner, to file a formal application in relation to the request for, I don't know whether it's a request for clarification by this court. I'll call it a request for clarification by this court as to whether the IEBC is properly represented by the council on record, or the council presently on record. How much time do you need to file that application?
I would file it by close of business. Now 12. By close of business tomorrow. And also, my
Tomorrow
Lord,
is the 16th?
tomorrow is 16th, yes.
16th. In service, same day?
Yes. Yes, same day, my Lord.
Any of the respondents want to respond? First to third?
My Lord, I was even suggesting a more efficient way to Mr. Mongela. Because we really want to move the matter.
Don't forget your name is...
My name is Gachagua Thuta. My name is Gachagua Thuta. Perhaps he can just have counsel who is with within IPC to be on record, then they can work together, just so that we don't proceed and then we just go back. That's a more practical solution. So that one of the advocates comes on record, then we can just come to it.
Yeah, but you see, I'm not going to stop work because of this order.
Very well, my lord.
We will finish with our pre-trial today.
Yes.
All right. I've also noted that this order was made on 12th of January.
Yes, my lord.
So I don't know whether it has effect
Yes.
backwards. I don't know.
Yeah.
These are some of the things you will tell me.
Sure.
And I'm sure you'll bring me all sorts of authorities and saying that
We'll get away
whatever
with
you
it, my
said.
lord. We'll get easy way.
So respondents, first to third.
My Lord, I'll be requesting you give us, this is Charles Mwangela for the first, second, and third. You give us until Wednesday.
I don't have a diary or a calendar right now. What's the date?
Wednesday next week will be on the 21st.
Yes, 21st.
File and serve your response by COB 21st. Fourth respondent, are you participating in this?
My Lord, you can file, this is Gachagua, we can file our reply by the same Wednesday.
Can I suggest that just so that we can speed this up a little bit, you file your responses with your submissions, your application maybe with the...
I'll also do with the submissions. My name is Gachagua.
You can do it with submissions.
Yes.
I'll limit your submissions to 3 pages, to which, of course, you might want to annex your authorities. Duly highlighted authorities to be annexed. Okay. So I think we were on the question of, we are still on the question of pleadings. So we've dealt with the pleadings of the petitioner. I know there are other pleadings like the application, the notice of motion. We'll come to that in a minute or two. Are these pleadings filed in soft form? Your pleadings?
Sorry, my lord.
Pleadings, are they filed in soft form?
Yes, they are, my lord.
No. I mean the pleadings themselves. Are they also in soft form?
Yes, the scanned one. We have not filed
no.
the Word version, which we can supply also.
Yeah, it's just to make it easier for us to copy and paste certain information whenever it's necessary.
Yeah, I can have that done
You
right
can do
away.
it. There's no emergency. We can do it in 7 days.
Very well, my lord.
Yeah?
I'll do that.
And the same for any future pleadings, just put them in soft form, also in Word format. Respondents, first to third respondents.
My Lord, perhaps before the respondents engages you, and I would beg to be guided by your wisdom,
Yes.
the direction that you've just issued about the application
Yes.
in regard to the import of the orders that have just been brought to your attention.
Yes.
My Lord, I am really begging to be guided by the court whether the pretrial can still continue when a challenge of representation has been posed to the court, because representation goes to the core of even the pleadings that we are just about to address you on.
Yeah.
My Lord, while I am aware that I'm at the bar, would it, my Lord, be prudent that this application be determined first, so that then the directions that will ensue from these proceedings will not have the possibility of being hindered by the subsequent ruling that you might give? Because you may find that Mr. Mongela is not properly on record, or you may find that he's properly on record.
Yeah.
What shall we do at that particular time?
Yeah. What I am going to do is this. Of course, I don't know what the outcome will be, but I am not going to jeopardize the petition on the expectation that the IEBC may lose their counsel. So we will proceed. If this is a nullity, let it be said in the Court of Appeal. Correct? It will be said in the Court of Appeal or by myself. If what we are doing is a nullity because of the absence of IEBC.
I understand you, my Lord.
You understand what I'm saying?
I do.
Yeah. So let's not jeopardize the 6 months that we have. They're actually now no longer 6 months, they are less. Let's proceed, and then when we come to a point where I have to drop my pen, I'll do so, if I have to. There is in fact another application, I think, for me to drop my pen.
Yes, ma'am.
Isn't it? But I have to determine it also, isn't it? I can't drop my pen first, then say it needs to be determined. All right. So let's go back to respondents' pleadings.
Yes, my Lord.
Yeah.
We have filed our response together with the affidavits. My Lord, we also confirm the materials are preserved, the electoral materials are preserved. At the IBC Embu office.
Yes.
My Lord, regarding the register, because the petitioner also filed a register, we felt that it would be prudent for the IBC to file the register also, because it is fairly bulky. My Lord, and if it were to transpire at some level of material contained in the petitioner's bundle is not what the IBC believes to be the register, then, my Lord, the best way to counter-check that would be by them relying on their filed register. So, my Lord, I have indicated in the affidavit, because of the challenge we were having in compressing the soft copy, that I would be availing it in hard copy, but in due course, we will be uploading it as well, the register. Otherwise, our pleadings are filed. We have also.
Have you looked at their register? The register. Already been filed.
I have looked at it, my Lord. As you can see, my Lord, we were just served last week, been working on up to sometimes midnight to go through this document and come up with a response. I will not say we have been able to really interrogate it, what they have. We just looked at their register very, very in a very cursory manner, my Lord. Therefore, in the interest of time, the 7 days timeline, we decided to bang in the register ourselves. So I'll be bringing in the register as well.
So you'll be filing the register within 7 days?
Yes, ma'am.
Okay. Fourth petitioner, fourth respondent. Pleadings. I think you filed some things today.
It's Adrian Kamodo for the fourth respondent. We have filed a response to the application, to the petition. The same is dated 14th of January 2026. We have equally filed a replying affidavit to the application dated 22nd December 2025. The affidavit is sworn by the fourth respondent on 12th January 2026. My Lord, the responses we have been able to do are based on the material that we were able to access from the portal. We were not served by the petitioner.
You are not served.
We were not served, but we endeavored to Yes, I understand there are some volumes that were served to my counterpart, but there are some items that are missing from the documents. There are annexures number 9 to 28.
So can we say that you are served with a petition then?
Yes, we can confirm we are served with a petition, albeit with missing items.
Some annexures are missing.
Yes.
Just
annexures
identify them, please.
Specifically annexures number 9 to number 28. And page 30 of the petition.
9 to 28.
Yes,
Annexures
in terms of
and
annexures. And then there's a missing page in the petition, that is number 30. Page number 30 in the petition is missing. We have also not been supplied with the video clips, and that was confirmed by Mr. Wathuta. We shall therefore be seeking to be supplied with all those missing elements, so that now we are able to comprehensively address the petition. So basically what we have filed is a holding response. It's an interim response because it may change once we have been fully furnished with all the documents underpinning the petitioner's case. So we shall be seeking leave to file a full response upon being served with all the missing documents and annexures. And equally to serve, and equally we shall seek leave to file witness affidavits as may be necessary once we have been fully facilitated with the complete set of documents.
So what I understand is that what you are working on is not actually the petition.
It is the petition, but partially because now there is information that we do not have, which has not been made available to us.
That is the
Which
missing.
may alter the trajectory of the response once it comes.
That is the annexures and page 30
Yes.
and the video clips.
Yes, the video clips.
But you have the petition itself.
Yes, the petition, save for the page that is missing, the page number 30.
Okay. Mr. Waduta, you have not served the petition?
My Lord, we did. We served soft copies first. Then all of them have hard copies. Mr. Mongela's hard copies are actually here. Mr. Gachagua was served, he works at Harambe House, 4th floor. My person went all the way and served hard copies. Mr. Gachagua, you can confirm that. Yeah, he was served.
Okay.
And there were 3 bundles, 3 very big bundles. In fact, one of them is a voters register, which council has confirmed and they have it. What Mr. Kamoto has suggested is that annexures 9 to 28 are missing. But then, again, he says those are the video clips. Actually, they are not the video clips. Annexures 9 to 28 are documents. The video clips are elsewhere. So, if it is a flash disk which was applied, I still have another one, even here, which I can still copy for him. So that by the time
What he said, as I understood it, he said some annexures are missing, that is numbers 9 to 28. Annexures 9 to 28 are missing, and also page 30 of the petition, plus the video clips were not annexed.
My Lord, I can see supply, but the bundle itself, this one, has those documents. I can still supply, but they are there. They actually annex just one affidavit, supporting affidavit. I'm still willing to supply it, nonetheless, even today. I'll just make copies of that.
Yeah, Mr. Kamado, just, you know, there's two of you acting, and I think you came at different times. Might there be a confusion between the two law firms?
No, there's no confusion because the document is here, and it can be, it's visible. It doesn't have page 30. The document is with us.
Well, the document
So
is very
So the page 30 is missing from the document. So that doesn't warrant any sort of reaction. You just supply the document. Then, my lord, I had stated that annexures number 9 to 28 are missing. We don't know what they are. Video clips are also missing. We don't know the contents. So if we can be supplied with those ones, then we'll be able to know the nature of the content, whether they are video, whether they are pictorial, and we respond accordingly, my lord.
Okay.
My Lord, I'm just trying to assist the court. And I noticed there's that disconnect. Mr. Gachagua actually has the file here with the big bundles, which was applied to him upon request at Harambee House. So it cannot be in that small file. So if you can just retrieve it, they are there.
My lord, allow me to respond. This is Gachagua. The petition is paginated 29, overleaf is 31. So there's no 30.
Is that the same in our bundle? Is there page 30? Petition itself. Okay, so there's a page 30 and there's a page 31. So page 31. So yours 30 is missing.
Yes, it is missing,
Okay.
and it's overleaf, so it cannot, it's 29, that one is paginated. And for clarity, my lord, the documents that are here, this bundle is what we printed from the portal.
Oh,
This is a
I see.
different one from what was served. So it means that these documents are also missing from the court record. And it will be necessary to ascertain. Because from the portal, we could also not get
Well,
the annexures.
at least page 30 is in our document, the hard copy. I don't know whether it's missing from the printed out version. Just a minute, counsel. Just let's check what we have. On the petition, page 30. Petition. And 31 are there. Okay, our printout from the portal has page 30, and the hard copy bundle that was served on us also has page 30. So there may be an issue somewhere else, but that is for you people to sort out. Eh? You're officers of the court. I don't know whether.
I'll still give him a lot.
All right, let's say
My
the direction is as follows. Let's not engage too much on this. Let's finish this discussion. Petitioner to serve the full petition afresh on fourth respondent. All right?
Yes, ma'am.
Just
Or is it just the pages
just
that are
the
missing?
Page
Oh.
30. This thing is very costly to make copies. Gachagua knows. He spent the whole day with my clerk.
My lord, there is a fundamental issue. It would appear that the document that the court has are not the same document that we have been supplied with.
No, this one is printed out
It's
from the
same-
portal.
The one that you printed from.
Yes.
So this one, as far as we are concerned, we have the full document. What I didn't see here were some of the annexures which were here.
Kindly confirm, my
So-
lord, whether it has a page 30.
It has.
does.
We've just looked at it.
This one doesn't have page 30, the one
Okay.
here.
I can't help you with that.
So that's why your order should hold that they serve us with the document, a replica of what they have filed in court.
But my lord,
This is something that we did.
Don't
and in
forget,
fact,
don't forget you have names.
My name is Gachagua Thuta. If it is only page 30, and Mr. Gachagua knows what we went through. And my lord, just for context, Mr. Kamogo came on record first, and we served him. Then later we saw another notice of address by Mr. Gachagua. So we went now started dealing with Mr. Gachagua. So whether they have coordinated that transition, I'm not sure. But Mr. Gachagua has all those documents. If it is page 30, I'll give him right now.
I'll give a direction in a few seconds.
only that, my lord, if you may, we might be invited to run to a risk by Mr. Kamodo's invitation, and if the order were to say that we serve, because the rules of service are very clear, and most importantly, Rule 10, so that then they may not say, we have just been served, we need to do a reply. I have heard him try to amend the rules by indicating that what they have on record is interim response, something that is quite alien in law or in our rules, so that then we only provide the missing page for purpose of fullness of record. But we are not serving because we have served, and therefore they will not be seeking for leave to put in any other reply because the reply has been served already.
Let me give my direction. You are replying to something else that has been raised.
I will not respond to that because I will simply say that there is no affidavit of service on record. So no service has been.
Just
My lord, it is already filed. It is on record.
Counsel, please. I will not accept the kind of interjections that we're having here. We will not proceed this way. Okay? You may be able to do that when you are doing your politics, but not here. All right? I will begin to. I have my gavel here. I don't like to use it. When I use it, it will have a meaning. Okay? So please, let's take it easy. There's no war. We have 6 months, and we are going to finish this in 6 months. Okay? We will do it. I have all the confidence in all of you as officers of the court. There are some things that don't even have to come to the court for directions. Some of those things you can sort yourselves out as officers of the court who have taken an oath to assist the court in accordance with the Elections Act. Correct? I think that's the way I'm going to treat this case. So let me give my directions, which are as follows. Petitioner to file, to serve pages pages 30 of the petition, missing annexures 9 to 28, and video clips or video clip within 7 days. Now, all pleadings that are pleadings, please don't forget that we also need them in soft form. In soft form. Has any party seen from the documents filed so far anything that is illegible? Any documents that are illegible that you would like to point out at this point? I'm looking at item number 5E.
On the part of the petitioner, we have not seen any.
Okay.
Perhaps because we have not been served. I think we'll be getting the documents. But in case of anything, we can resolve it among us council.
And you can still raise it. This is the first pre-trial.
Yes.
There will be opportunities for us to raise any issues which are concerning us,
Yes,
which
yes.
are bothering us
Yes.
as we go along.
Yeah. Anything I can always raise with my learned friends.
anything that you've seen that's illegible?
Yes, Adrian Kamodo,
Yes.
for the respondent, we have the register that is not legible, as is clear.
I had challenges myself reading the register. Let me not pretend that I read the whole document, so that I just perused, a quick perusal. I flipped through. I can't. I think it's a scan. Is it a scan?
We were given an Excel, and then we just converted to PDF. What was given to us in a flash disk. We just
Okay.
got a soft copy, then we converted to PDF.
Yeah. Are those pages illegible, or is it that they are not as clear as we'd like them?
But my lord, because we have the register in a flash disk that came from IBC, we can still supply it to court, so that then whichever pages you'll be referring to, the court can easily go and magnify or expand.
Page 24, 64 and 65 and 66 of the petition appears to need a bit of help for clarification. That's 24 to, sorry, 24, 65 to 67. No, to 66, sorry, to 66. 64 to 66.
Yes, madam.
It's a photocopy and it's not legible in aspects.
Sure. We can supply clearance.
Yeah.
Yeah, we have your dreams.
Okay. It may even have no bearing on the actual case, but let's have it clear. Now, I'm moving to item number 7. Sorry, IBC. I don't think I had you say anything about clarity of any documents. Are there any documents you struggled with reading in terms of
My lord, if I
legibility?
come across any, I'll point it out.
Okay.
None at the moment.
Yes, Council.
My lord, and sorry for taking you back. About the register, I had made a request that we supply the court with a soft copy as received from IBC, so that just in case the court needs to refer something, we can just expand on the screen, because we have an Excel. It's an Excel? Yeah, it's not, yeah.
You
it's an
obtained it from IBC.
Yeah, they gave us a soft copy,
Okay.
which you can supply to.
The original register is probably with the materials which are preserved.
We will be supplying, my lord, we will be supplying
The original.
the register, a physical copy as well as the soft copy.
Is the original register available?
Yes, my lord, it is.
It is.
Yes,
Okay.
yes.
So what you want to make is a photocopy of it?
We have it in the system. We generate, because even the petitioner, my lord, what he would have done,
Yeah.
and which I'm not aware whether they did that, was they were supposed to apply for the register from the IBC and they pay the requisite fees, which apparently I'm informed may not have happened, and that is what part of the reasons why I'm insisting on filing the register myself.
Okay.
Yes, my lord.
Yeah, my lord, Kiragwa Dhuta, for the register, indeed, we applied formally and paid a fee of 20,000 shillings. We have attached the documents to show the chain, how we got the register.
Let me make an order for IBC to avail the register to court and parties in soft form, to parties in soft form, to the court Let there be an original. I'm looking at F now, 5F, trial bundle. I know that would be an expensive process if we go the way we sometimes want to go, which is to prepare, each party prepares the document that they will be relying on at the trial. There are lots of other papers in the file which we'll have dealt with, like all the applications, we'll have dealt with the applications before then. So are you willing for us to have a trial bundle? Petitioner?
No, they are too bulky to consolidate.
bulky.
Yes.
All right.
My Lord, we intend to, because mine is paginated in batches, I wanted to file a paginated bundle, a complete bundle. I'll be doing that.
Fourth response.
Adrian Kamodo for the respondent. We will also file a trial bundle, properly paginated, and we will also be seeking that the same applies to all the parties for uniformity of the court records.
Now, I know your trial bundle, 80% of it is the register.
Yes, my lord.
If I ask you to omit the register,
Yes.
we know you have filed the register.
Yes,
we
ma'am.
will have the original register from IEBC.
Yes.
What you have filed is still there in case there's a difference between what IEBC gives to the court and what is contained in your documentation.
Yes, my lord.
Can I ask you to file a trial bundle without the register? That's the only thing that will be missing.
Yes, my lord. I'll do that. By trial bundle, I thought is what we normally do, a consolidated bundle of all the pleadings.
All pleadings for trial.
For trial.
I don't want for applications.
Yeah, so that then if we separately or differently, so maybe we can just say as we do the petitioner's trial bundle,
course.
each party to do their trial bundle.
Oh, of course.
That one, my lord, will. That
Yeah,
one will do.
That's the way it would be done. I wouldn't expect you to do a trial bundle for them.
Very well, my lord.
You
That
might
one
put
will
in documents they don't want to use.
do. That one will do, my lord.
Okay.
We do that.
So it's a trial bundle then for each party? Can we say how long? How much time? Is 7 days?
That's enough.
7 days. Within 7 days? G, deposit of security for costs. I think that was done. I have seen the receipt. Is there any issue on that one?
My lord,
Let counsel speak.
Well, I was trying to guide him because I had him raise the issues, and I was reminding him that we are dealing with the petition number 2.
Okay.
no, I was just raising something before we move to security for deposit.
Yes.
On the time interval for the trial bundle, noting that we may be supplied with new documents and take time to prepare something.
I'll give you 14 days. Let's do 14 days.
Very well, my lord.
There's no emergency. We'll be dealing with the applications in the next number of days, or maybe first 2 or 3 weeks. So the actual trial will begin a little later. So let's do 14 days for the trial bundle. Deposit of security. Is anybody objecting to that deposit? Has anybody not seen that the deposit was filed? Okay, let's move on to the next item. Court proceedings and transcript protocol. I don't know whether the ICT people have already issued you with the standard operating procedure for speak in court and how to ensure that you are heard. There was a document I saw. Yeah. Have you? Been given a copy of this document? You have? All right. The guidelines for digital recording. So we can say that has been done. You will also be responsible for ensuring that the parties that you are representing and the witnesses understand that they have to speak up, speak into a mic, say their names every time they speak. Can I take that as agreed? Transcripts, I think we mentioned this earlier. The transcript of proceedings will be available on the second day. So today's transcript would be available on Saturday, but probably available to you on Monday. You have an opportunity to look at it. It will be a transcript, so I don't think there will be too much argumentation on it. I don't expect there to be. You'll have an opportunity to look at it. Just in case we have missed a whole page, you will let us know on the third day. That's what item 6C2 refers to. 6C2. If you want a printout of the proceedings, I understand there's a cost of 60 shillings. Is that still the same? It's 1,000 per page for the whole proceedings. Oh, you should charge make a better deal than that. So it may be very long. Okay, so it's 1,000 shillings for all proceedings, for the full proceedings. As I indicated, I will be writing proceedings such as I am doing. They will be notes rather than proceedings, which are personal. Let's look at some pretrial matters. There's a question of mandatory consolidation. Because the two petitions, number 1 and number 2, relate to the same election, they should be heard at the same time in the same hearing. Now, you want to speak before me?
No. Sorry, my lord, I thought you were done. I wanted to rise on.
No, I am not done. I'm going to make a suggestion. I have seen that there's an application to strike out that petition. And submissions have been filed by all parties other than the petitioner. So my presumption is that given the clarity of the law on that question of deposit, I do not expect that that matter will be proceeding. Is that correct?
That matter in terms of the petition?
Yes. Petition number 1.
My lord, we have put grounds and we have explained the reason why we are here, we are where we are. And it was anticipated that at this point, the two petitions will be consolidated because petition number 1 is one item in petition number 2. So that then upon consolidation, that issue of the security deposit, which has already been deposited in number 2, will be moot.
Yeah, but petition number 1 has no security deposit. That petition cannot be consolidated because it does not comply.
Very well. Maybe what you can do, the issue of security.
In fact, I was going to make it very easy for you.
Yes.
I was going to say, instead of us taking a lot of time on petition number 1,
yes,
which is subsumed in petition number 2,
yes,
withdraw petition number 1, and we'll deal with that question which you have raised in petition number 1 in petition number 2. It's the same question, isn't it?
Yeah, my lord. Yeah, that's what we are consulting here, and
I can give you half a minute.
Yeah,
just
we actually
consult and agree.
In 1 minute.
Yes, my lord, that would be sufficient.
Who is the lead counsel? Yeah, just give me one answer from the.
Yes, my lord. We would go with the option of withdrawing petition number 1, which application we hereby make, and having those issues subsumed in petition number 2. And with no orders as to cost.
I have a bit of a challenge.
Yes, my lord.
Petition number 2
Yes.
takes over some of the items in petition number 1.
Yes, my lord.
Those are the ones that are subsumed.
Yes.
When you say that it is withdrawn, but the items in it are taken across to petition number 2, there's a bit of a difference.
Yeah, my lord.
What is in petition number 2 is what we will continue with.
That's fine. We can still argue. Yeah. On our side, we can still argue those issues in number 2. So I think we can just make it simple for you.
Petition number one to be withdrawn.
Yes.
In your case, you pray that it be without
Without
cost.
cost, my lord. And just for clarity, I've not seen a response from Mr. Kamotho. He hasn't, at least he hasn't filed in response to that application, to that petition. And Mr. Mongela has not served me with any response to that petition.
Okay, okay. So your prayer is for it to be withdrawn with no orders to costs, first to third? Oh.
Yeah, my lord, I've just been informed, sorry for taking you back. I understand the clients are present in court. Maybe.
In petition 1?
In petition number 1.
Yes.
So just for good order, I would rather when we take a break, we just consult them before that application is dealt with, so that then we are on the same line, because we may not be able to make a full decision.
In court here?
Yeah, I can see the wisdom in it, but then maybe the petitioner will see it differently.
All right. So you want us to delay this decision on consolidation?
On consolidation, my lord.
We can pend it for a couple of minutes. I don't think I'll give you too much time. I think one of your counsel should go out with them and have a discussion.
We'll do that.
So that we are not going to delay what we are trying to do.
Indeed, my lord.
Today is a pre-trial.
We will not delay.
That was the first petition that was filed. In fact, the date of today was given in line with petition number 1, not 2.
Yes, my lord.
So petition number 2 had to come in, although it is very much later in terms of time. So one of your counsel will have to go and have a chat with them, and then you come back to me while we are dealing with the other items.
Very few minutes, my lord.
My lord, before they are discharged, we have an objection to that line of progress, because the file before the court is E002 of 2025. Counsel for the petitioners has raised issues relating to a file that is not before the court.
That's what, counsel. Really? You are splitting hairs. I know we are dealing with petition number 2. Don't think I am so poor in my understanding as to not understand that we are dealing with petition number 2 and that I am the one who raised the question of consolidation. Because it is a requirement in the law. Petitions of like parties to be consolidated.
My lord, I'm in agreement. Allow me to make my point on that. My prayer is we deal with the issues in the file number 2, and since we'll be going back to file number 1, because as it confirms the parties are there, we deal with the issues there comprehensively, because we have applications pending in that file. We have applied to strike it out.
That's fine, counsel.
So we pray that
if you like, we will even go through the whole process, the whole of this process in petition number 1.
I so pray, madam.
If you like. But for now, I'll give, for petition number 2 to be complete, is it going to be consolidated or not? And I will need to have an answer to that.
In few minutes, my lord.
All right. Issues. We are looking at page 4 of 7. Contested and uncontested issues. I think it may be a bit early because I saw the response today from 4th petitioner who is indicating in any event that you have only filed a holding response. Is that correct?
That's correct, my lord.
But let me tell you what I see to be the issues. I think in petition number 2, one of the key issues will be whether the fourth respondent was eligible to contest. All right? That is one of the key issues. There may be some sub-issues in it, but I think that is a key issue. The second key issue is whether the overall outcome of the election reflected the will of the people. And under that, there are also a number of sub-issues, for example, irregularities in counting, sourcing of the wrong personnel, and so on and so forth. All those, they are all in the petition. Other than those two key issues, is there something else that the parties really think this court will be determining?
The
Yes.
standard one. The standard one. Who shall bear the costs?
Okay. For that, as when we come to the towards the end of this, we'll even discuss how costs will be dealt with. Okay. But those are the two key issues that I sort of saw, and I know there are sub issues in them, so that we are not straying too far from what is the core of the case. Is that correct? Adrian Kamodo, you don't look happy today. I want you to be happy, to smile for the camera as an officer of the court. Are you okay? You have something to say?
Well, I'm hoping that the court finally will put a smile on my face.
Okay. You mean at the far end? All right. We'll see.
Yes, my lord, I think we can upload those as the major issues
The two
for
major
determinations.
issues. Okay.
With sub-issues, as you said.
There are sub-issues. Any counsel with a different opinion on that? Including, of course, the issue of costs, which we'll come to towards the end. Then now we need to identify the interlocutory applications that have been filed. The first one is the one in respect of which we have just made some directions. It's not actually the first, it's the last, because it was raised today, and the application itself has not even been filed. But there is the certificate. I think it's here. The notice of motion and certificate that came up on 22nd December by the petitioner.
Yes. Yes, sir.
And I think I only dealt with item number 2 in that notice of motion of 22nd December.
Yes. Yes.
Items number 3 or prayers number 3 to 9 are yet to be dealt with.
Yes, my lord.
So those will be the subject of responses and directions today. Can we give directions?
Yes, we can.
Okay.
And perhaps maybe I don't know whether there is any that is objected, because if he's conceding to some, then or all of them, then we don't need to do much.
Let's see. On applications, that is the notice of motion dated 22 December. Prayers 3 to 9 are the ones which have not been dealt with. Directions. Are these challenged?
Yes, my lord.
Yeah.
The application is challenged.
Yes.
Yes.
So they are challenged, Mr. Kamodo?
Yes, Adrian Kamoto for the fourth respondent. I confirm they are challenged.
They are challenged. So let's me give directions then on the responses. How much time do you need to file a response? You've had this file now for a while.
Yes.
How much time do you need to file a response to that notice of motion?
7.
7 days.
Yeah.
Filed and served within 7 days. They are both respondents the same?
Yes, my lord. This Gachagua will need 7 days to file.
Within 7 days. Also 7 days. Do you need to file a response or
Yes.
reply to that?
On both, which can come together with submissions.
It can come with submissions.
Yes, my lord.
Do the respondents want to file submissions, responses?
My lord, since it is the petitioner's application, it should go first with the submissions.
Okay.
Yes. So maybe you can put in the submissions together with the
With this
rejoinder
with
which he's
rejoinder.
talking about. Then we put in submissions.
Yeah. Okay. Let's don't forget we can do anything we really want. Eh?
Yes.
Yeah. But I see the sense of doing it that way. I'm sure it's the same for you.
Yes, my lord.
So let the rejoinder by petitioner be filed. I think 3 days should be sufficient.
For the
Rejoinder. The application is yours,
yes,
so you have all the information in the world.
Yes,
You've
sir.
had it actually since last year.
yes.
So you're just filing a response to what they are saying in reaction to your.
Yes, my lord. I can squeeze myself. It's only that now that I'm doing together with submissions,
You have so many.
I was seeking
counsel
some grace. Very well, my lord. 3 days is okay.
Within 3 days.
I can do that.
Because we want to hear all the applications and maybe more may come as we go along.
Very sure. 3 days.
Filed within 3 days, filed and served
Yes, my lord.
of today's date. Together with submissions.
Yes, together with submissions.
Just give me the diary, please. Let's see how it is. Have you filled in material, other matters that you're dealing with already? Some of these matters will suffer. Yeah. Respondents' written submissions, how long?
My lord, we are ready to do that 3 days upon receipt of the petitioners, applicants.
Same, come up?
Same for us.
3 days. Within 3 days after being served. I think we may want the submissions to be a little lengthier this time because I think the number of items and the gravity is a bit heavier. Is 7 pages sufficient?
Yes, my lord.
Yeah.
I think even in the Supreme Court, that is usually the limit.
7 pages. Submissions limited to 7 pages. 7 pages submissions?
Yes.
7 pages, yeah?
Yes.
To which authorities duly highlighted shall be annexed. I think we may need to highlight these ones because you are referring to documents, lots of documents. You are looking for scrutiny. You are looking for recount in some cases. So there may be a need for you to demonstrate to me through your submissions what your documentation says. I'm talking about the petitioners.
Yes, my lord.
Yeah.
When I saw your directions, my lord, I was hoping the question of scrutiny could be determined in the trial. sometimes we inquire
In the trial.
in the case. They can be
But
subsumed.
if they can make a case for it now, why not? They have an application.
Fair enough, my lord.
That application includes an application for scrutiny. I hear you.
Yes,
We can still redo it
yes.
at the time of the trial if the justice of the case requires. There's nothing that we can't do. Yeah, but I understand what you're saying.
My Lord, and I again beg to be guided. I want to borrow the wisdom by counsel for the IBC that we have to lay the basis why we need to either have scrutiny or recount. My Lord, would it be sufficient enough to lay the basis through the affidavit, or we might have to have the witness at the dock and lay the basis why we need recount or scrutiny in a particular polling station? Because basis must be laid, and that's the jurisprudence. And if we take at this time, my Lord, will it prejudice our case as the petitioners?
I actually have two options. If I decide that the petition outcome, that the two parties are very close, I don't have to have a basis laid. And that's our jurisprudence too. So there are cases where 127 votes was considered very close, and therefore no real basis has to be laid. In this case, you have about 494. The difference is 494. I'm not sure whether it is too close or whether it is very far. Is too close less than 100, or is it more than 100? It's a discretionary point. Mr. Kamoto.
Yes, I can respond to that question.
Yes.
Yeah, there have actually been smaller margins than that, and the winner has always been declared to be validly elected. So
It's true.
those small margins are common
No,
in
no,
that
no.
part of the
We are not
country.
talking about the outcome of the scrutiny. We are talking about whether or not scrutiny should be done or recount. So you can have a case where the difference is 10, and the person who was elected at the first instance remains elected. Is that what you're talking about?
I'm in agreement with the perspective by the court. I think
Yeah.
it's true. It's
Yeah.
possible that even the margin is 2 votes, but
Yes.
still the process is sustained.
Correct.
Yeah, my Lord, we've just whispered with Mr. Mongela, and we've also agreed that after we leave this place, we'll also continue to engage and see which parts of the application can be resolved as you go along, so that we don't have to submit too long on things that can be settled.
Excellent.
Yeah.
Thank you. That is exactly what we are looking for.
Thank you.
That kind of cooperation between you as officers of the court. Sometimes you are always fighting. And I know you are fighting for the rights of your parties.
Indeed.
That's totally understandable. But you are now, that is real assistance to the court.
Thank you.
Yeah.
Thank you.
So should we retain the orders the way we have done them?
We can, my lord, we can, but the challenge I was finding is,
Yeah.
if you look at the nature of scrutiny which is being sought,
Yes.
it is not just the scrutiny of the ballot. There is sought therein, my lord, scrutiny of the technology which was used.
Mhm.
And those are some of the challenges we are having with whether a basis can truly be laid, my lord, or rather whether it will not have been proper.
Just highlight, for example, the ones you're talking about. I'm looking, for example, at number 4. Notice of motion, prayer number 4.
Yes, my lord.
Is that one of them?
Complete KIEMS logs, which, yes, those kind of things, my lord. Complete KIEMS logs, KIEMS servers.
Yeah.
My lord, we would have wanted you to hear the witnesses so that you know whether there is anything which is questioning the KIEMS logs, really.
The witnesses have already testified through the affidavits.
Okay, my lord. It's okay, we can find it.
Let's do the application.
Yes,
Because it is open to me to give directions.
yes.
Having heard what the application is saying and
Yes.
what the parties argue,
Yes,
I can still say I don't think
yes,
that we are yet ready
yes.
to deal with the Kim's issue. Let us proceed for hearing.
I hear you, my lord.
What I don't want is for us to be having applications coming up again during trial.
Okay.
Because we are going to, today, we will discuss when is the last application going to be made.
Thank you, my lord.
Okay? So that we have a roadmap. When we set dates for trial, it's just trial. We will not be having applications pending as far as possible. So let's retain the orders the way we have given them. 7 pages of submissions with authorities annexed, duly highlighted. Then the second application, we have already given orders or directions for it, and we concluded that. Is there something that we did not deal with in the second application, the one that came up this morning?
That one we had already concluded.
We had concluded.
Yes, ma'am.
All right. So for this particular case, I don't think we have any other applications.
There is, my lord.
Yes.
There is an application by the fourth respondent.
Oh, the one that was filed today.
Yes.
This is a motion for. This is the one for striking out.
Yes, my lord.
But you want to strike out the whole petition on a question, on question 1, which we agreed is an issue.
No, my lord. It touches on all the issues, even the irregularities.
Okay.
Yes.
Maybe council can just supply us with, even if it's a soft copy. I think he has my number, so that then we can just have a look at it. Yeah, he served my office in the morning when I was here.
I see in your relief, even to the response. In your response, your relief is that the court lacks jurisdiction.
Yes, my lord. That's our.
Okay. I don't quite capture it, but maybe you'll elucidate. So we can take directions on this one. This is the application dated yesterday. It's dated 14th January.
Correct, my lord.
Yeah. The fourth petitioner's application dated 14 January. Directions, respondents, 1 to 3.
7 days.
You file and serve a response within 7 days of today's date.
Yes, my lord.
IBC,
Can you give us the same duration, my lord?
you want to file submissions?
Yes, my lord.
How much time do you need for submissions?
My Lord, you can give us 3 days, but we'd also seek leave for further affidavit in case they raise issues that we have not addressed.
In their response.
Yes.
Why don't we give you the liberty now?
That's okay.
Applicant to file a response to the reply, if any, within 3 days of being served. In which case, I'll now ask you to file your submissions together with your reply.
Correct, my Lord.
Both respondents to file their submissions within how much time? 7. Petitioner. Lead counsel, you're not speaking. The other counsel who's speaking a lot is busy.
We are consulting on how we will help the court. My Lord, I think we can take 3 days. 3 days.
Within 3 days of being served.
Yes.
Respondents to file written submissions within 3 days of being served with the applicant's submissions. Written submissions not to exceed. How much time do you need for this in writing?
Maybe 7 pages, my Lord.
7 pages?
Yes.
This is a small application, I thought. Although it's for striking out. Huh?
Yes. That's why we need that.
7 pages. Written submissions not to exceed 7 pages in all cases, to which authorities duly highlighted shall be annexed. Is there any other application pending in this matter? I'm not aware of any. Would you be agreeable to hearing both all the applications on the same day?
Yes.
Yeah? Yes. So that you're not also coming up and down all the time?
Yes.
Or would you be happy to do it virtually? Does that make it easier?
Yes,
No.
being applications,
Mm.
we can highlight. Furthermore, we'll have found submissions anyway.
Yeah.
We can highlight virtually. Applications, we can come here for the hearing.
Okay. There are those who may want to come physically. I can do hybrid.
Yeah, that's fine. Because, my Lord, given the volume of documents and documents flying left, right, center, perhaps even if counsel will be appearing virtually, let him just have one person here in court. At least, just in case we need to retrieve something first.
Kamotho?
On our part, we shall be glad to appear virtually. We'll be able to furnish any document Mr. Wadhuta will require on the spot, virtually, because it's an application. But for the hearing, then we can show up physically.
Okay. So I'll do it hybrid. Those parties who want to come here physically can come physically. Give me a date for the hearing of the applications. There are now 3 applications.
On the 12th of February.
What kind of a day is that? Thursday, 12th of February? Is that agreeable to the parties? Any party that's for which that date is inconvenient?
It's okay with me, my lord.
Okay. IBC is okay. Kamotho is okay. Twelfth of February.
My lord, we are requesting 17th if it's convenient and available to the court.
How does 17 look? It's a full day. Yeah, we'll have a problem because the court will be crowded with civil matters. So civil matters can go very long. 12, we have only 2 matters. What about even 11th? 11th?
Getting that week is a bit.
Yeah. Unfortunately, we had already taken dates for the normal calendar because we didn't know about the petition being filed when we were taking dates last year. So we are trying to look for dates where you don't get inconvenienced.
Let's try the 12th.
You can try the 12th?
Yes.
12th?
Yes.
12th?
Yes.
All right, thank you so much. 12th February 2026. In our diary, will it be the first matter? They're both here. Yes. Do you see how many witnesses there are there? Because this will be heavy, there will be 3 applications. Can we have you at 9:15? 9:15 on that day?
Yes.
Yeah. So there'll be 3 applications, so I expect it to be fairly lengthy. The session will be hybrid, both virtual and in person. All right. We look at witnesses. I don't think we can deal with witnesses for petitioner number for the 4th respondent, because your witnesses you don't know yet, isn't that? Is that what I had understood?
Yes, that's the position, my lord.
But for the petitioner, we have seen your witness, or we now have a sort of schedule of the witnesses.
Yes.
I think you are 14.
Yes, there.
There are 14. Are there any that you wish to remove at this stage, who are repetitive, for example?
Not at this stage. Maybe after we do our internal reviews, we might 1 or 2 things might change.
Okay, so 14.
But I will be glad enough to inform the court.
Okay,
Yeah.
14 witnesses to be reviewed. IEBC, I think we saw, what, 4 witnesses?
No, my lord, excluding the respondents, first and second and third, we are given 8. I know there is one in the list whose affidavit has not been filed. We are given 8. They are annexed at the tail end, my lord, of the second respondent's affidavit.
We have 10 witnesses on the replying affidavit.
Yeah.
And then there was an indication of one by someone called Paul Wachanga, but that affidavit was not.
Yes, my lord. Yes.
What are you saying about them?
My lord, what I was hoping to do, or rather what I will be seeking to do, is because of the timelines, basically it was a matter of timeline, I will be seeking to file an application to put in 2 witnesses.
2 additional witnesses.
Yes.
So that there will be 12.
Yes, I could not be able to meet the term because of the pressure of time.
Will there be any objection to that?
Yes, my lord. My lord, my name is Dego Njiro. Council needs to be clear whether he's moving you with that application now or it is filing an application, because to the best of my reading of the rules is that we are here for a pre-trial because pleadings are closed.
No, not because pleadings have closed.
Number two,
Because petition number 1 forced me.
okay.
Yeah, that's how petition number 2 comes.
Let me just clarify that.
Yeah.
Well, while I want to give leave to him to respond, then okay, I'm well guided then.
Yes, my lord, maybe I can clarify to my learned friend, Mr. Ndegwa. I'm seeking leave to file an application to introduce those affidavits. My lord, it will be determined in the application. You cannot say I won't file an application. I'm seeking to file an application informing you, my lord, within 3 days.
Okay.
Yes.
Yeah, my lord, let's just make it simple for Mr. Mongela. From our end, we don't have a problem. He may not even need an application. Let him seek leave, and he gets leave to file the affidavit.
You are an Article 159 person, eh?
Yeah. I mean, we have to move forward. Yes.
We'll be glad, my lord.
Now let him
That resolves it, my lord.
Let him
I'm happy to hear from the petition.
Mr. Kamotho and your team?
We shall deal with the application once it comes. At this stage, we are just spectating.
You're just
Spectating,
spectating.
yes.
All right. So we know we have 14 witnesses for the petitioner. We have 10 witnesses, potentially 12 witnesses for IEBC. And there doesn't seem to be opposition to allowing them to file two additional witness statements. Is that correct? Is that correct?
Yes, my lord.
No objection.
Yes, and also from us, no objection.
No objection. IEBC to file 2 additional witness statements. How much time?
My lord, since I'm doing some filings by Wednesday, let it also come by Wednesday.
3 days of today's date.
Yes.
Yeah, my lord, with that status, then maybe we can just get leave to file any further witness statement or affidavit, or actually affidavit, which may become necessary as a result of those further filings, now that they are not on record at the moment.
Petitioner is
My Lord, we will pray that the same benefit be extended to us.
My lord, while I do not want to appear antagonistic, I'm just wondering, my lord, whether your rules will, the directions will give will affect the rules on service and the number of the days when a response must be filed. Because for me, I am looking at the law. 10 days have lapsed since they were granted an opportunity to file. How shall we open that window for him to file replying an affidavit for a witness when time for filing has closed?
Yeah, I think the jurisprudence is that we can extend.
Okay, my lord.
That's
I'm
why
well
I'm not
well guided,
too
my
worried
lord.
about
I'm well
this.
guided, my lord.
Yeah. Yeah. Even amendments can be made.
I'm well guided.
You said something, Kamotho. I don't think I captured what you were saying.
Very well, my lord. I had thought that the leave to file further witness statements be also extended to us along the same lines that Mr. Wabuta had prayed.
What, you're seeking leave to file additional?
Yes, additional witness affidavits.
Is that objected to?
Not at all.
IBC?
No, not at all, my lord.
No objections. So, fourth respondent is granted leave to file additional witness statements. How much time do you need?
Fourteen days will be sufficient.
Within 14 days. All right. I think we have
14,
yes.
Same 14 days.
Oh, within 14 days also.
Yes.
So we can deal now with item number, I think we can skip 5. Let's move to item number 6, scrutiny and recount the applications which are pending. So I think that will be dealt with through the applications. Election material. IEBC is in custody of the election, all election materials.
Yes, my lord. We confirmed that, rather we do confirm the materials are completely preserved.
Okay.
Yes.
Looking at the way the pleadings are written for the petitioner, petitioner, do you have anything to say?
Yes, my lord. There are certain materials which we would like to be kept in the custody of the court. And we were hoping that issue will be addressed in the application for scrutiny. And I would like to, at that point, we come and argue and see what materials can be secured by the court from a certain juncture. So as long as the order is complied with as confirmed, then we can come and make further measures to secure some bit of the materials. So for now, as long as we get that undertaking, then we can move.
Maybe just to improve on that, my lord, perhaps the IBC could give us an inventory of what is in their custody in respect to this particular election, and the inventory be filed before you. So that then, my lord, we are aware that if it is Kim's kit number X, it is in custody, it is within the reach of the court through an inventory. And number 2, perhaps, my lord, where I've seen the practice where parties have always been allowed to also secure the materials. If it's a ballot boxes, perhaps parties are also allowed to put in their security systems.
Anything from Mr. Kamoto and your team?
Well, we would not have an objection, save for the fact that it's a statutory duty for the first respondent to preserve the materials. So issuing an order on top of the statutory requirement would be superfluous in our view.
What do you mean by that?
That the IBC, by law, is required to preserve the materials, the election materials. And there is an order there's an interim order that has been given by this court on the 5th of January 2026, which states that Prayer 2 is granted. The IBC is ordered to preserve in safe custody all election materials used in the Mbeere by-election that was conducted on 27th November 2025. So anything on top of that, unless there is something I'm missing, would be non-essential. That's all, my lord.
My lord, if you may, my lord, my name is Dewanjiru. There is a by-election that has already been gazetted for the same region. We are not sure whether they are going to use the same, especially the KIMS kit, for purposes of that by-election. That is important, my lord. The KIMS kit and the election technology that was applied during this particular time be preserved by the court, and that technology be known by the court. What exactly are you holding? So that, my lord, we are not told that this KIMS kit has been configured, it has now been used for the by-elections in the wards.
I'm aware of 2 wards in respect of which there is another election.
Yes, ma'am.
Uh,
There's a by-election, or rather by-elections, my lord, on the 26th. Charles Mongela, my lord.
yeah.
First, second, and third respondents. My lord, there are by-elections scheduled for the 26th of February within the same constituency. My lord, the best keeper of these materials is the IMBC, my lord. That is where they are kept prior to the elections. That's where they are kept after the elections. The petitioners' fears, my lord, can be addressed by requiring or giving them leave to earn additional seals. We have no problem with that. They can earn additional seals, of course, at their own cost. Because the seals, my lord, which were placed at the polling stations are still intact.
There was a question which was raised by Mr. Ndegwa about the items that you may be using for the 26th.
Yes, my lord.
Are they the same, or will they be replicated in the other election?
My lord, I think that's a matter would require to consult. My lord, the commission will deploy other materials, other equipment rather.
Okay.
Yes.
Okay. What is it?
Yeah, Your Lordship, Kiragwa Dhuta. What I can see, and now we can see the direction we are taking, especially now that there is a by-election, and there's something which we are seeking which is not really contested, just the logs. If Mr. Mongela can just share the KIMS logs, which we are seeking here, it is not contested, then, and the serial numbers of the KIMS that were deployed during the by-election, so that when the by-election is again done in 26th February, we can put side by side and see whether it is the same equipment that was deployed. So I don't think anything much. There is anything not to disclose about the serial numbers of the KIMS used and the logs of the people who identified using those KIMS logs. So basically, it's an inventory that we are asking of materials which do not change much with regard to the technology at IEBC. So if we can get that, we are good. Just the logs and serial numbers of the KIMS, so that the logs are put against each KIMS serial number. Then in future, when we do the by-election, we will still be appearing before you, now in the main petition, so that then we are sure that is not what is being deployed. About the seals, again, thank you so much, Mr. Mongela. We'll do that. We'll come and put additional seals to the boxes.
So when you say that you're looking for an inventory, particularly with regard to the items of an electronic nature, what are you asking for?
We are just asking what happens is that each KIMS kit has a serial number.
Yeah.
So what we are asking for are those 130, the 132 serial numbers of the KIMS kits that were deployed. Then, under each KIMS kit, there are those people who are identified through those KIMS kits. So say 100 people, these are the logs. So it is just that we are seeking for now. Then they can even deploy the KIMS kit in another election if they so wish. But just to avoid that confusion at that point, you can just get that. It is something which ought to have been shared anyway. But now we can just get it. And I don't think Mr. Mangela would have a problem with that.
I have space in my courts for anything that needs to be preserved.
My Lord,
We have made arrangements, if necessary, for everything to be brought here. It can be brought here. It can be secured. And I think that is probably the direction I want to take.
yes, my Lord, because
That, Councillor, it's me speaking now. Please sit down. I think just looking at the way the petition was conducted, and I'm not saying anything other than the fact that it was conducted, but looking also at the reports that were made, that were in the public knowledge, I think it is best everything be kept here.
Yes.
And everybody be given a key with a padlock. Not a key, keys. Your padlock and your keys. I thought seriously about this because when I read the petition and the responses, I felt the confidence of the court is going to be looked at here from a different angle if we are not very, very clear on who is in control of the process. So the order I'll be making is that all the preserved materials be brought into the custody of the court. I will give a direction in due course so that the registrar will be able to have a meeting with IEBC and all council. You will be shown where the materials will be kept. You will be able to see that we have secured it. There are places for 6 padlocks in the premises where you will be shown. Padlocks will be purchased by the court, and each party will be given its padlock and the 3 keys or 5 keys, whatever number of keys that come with the padlock. Nobody will be able to access the place, that premises, without all the parties being present or with their keys. And one of the directions I'll give in that regard is that if a party fails to attend on a date on which access to that room is required and therefore delays or causes delay to the other parties, we will break the padlock and they will lose access to that premises. Is that a fair way to proceed?
Absolutely.
Is that a fair way to proceed, Kamoto?
It's extremely fair.
Thank you. That's the order I'll give. I know ABC may not feel this is the best way, but you are the ones who are respondents. And I'm not saying anything about IEBC by making this order. I'm just saying that the public, I think, will feel more secure.
Yes, ma'am.
That way.
Completely. We understand, my Lord.
You understand?
The context in which this is being-
Excellent. We have ample security here. I think you've already witnessed it. And that room will be under 24-hour guard by armed officers. All right? So that's the way we are prepared for this, because we also have a fair amount of support. Since there are not 30 petitions all over the country, it's easier to deploy more facility and resources here. So that's the way I'll do it, and I'll give an order to that effect soon after this. All right? Yeah. I think for everybody's sake, it's better. Even for IEBC, it's better. Whatever you have, just bring it here. Busy yourself with the other petitions, with the other elections, I mean. Okay, don't be bothered with what is kept here. We will only deal with what is kept here if scrutiny has to be dealt with. There are applications, aren't there? We will deal with those things at that time. It may turn out that we may never have to open that place. If we don't have to open that place, we will give you the security. We have security. You'll be given security to take the things back to where they belong. And the officers, police officers, are available for that purpose, both for collecting and bringing here and for returning. Okay, so we'll make those arrangements.
Yes, my Lord. As you are well guided by the directions of the court, my name is Dewanjiru. Perhaps, my lord, Mr. Mwongela needs to inform us, because he'll be bringing the KIMS kit from all the polling stations in the constituency, whether we'll need to have a preliminary log-in for us to ascertain whether these are the actual KIMS kits that we're dealing with, or on a physical glance of it we can be able to determine. So that, my lord, the registrar will have the opportunity of taking record of what have I taken in custody.
Why do I suspect that that is the kind of order that needs to be given at a later date? Not now. Because right for now, let everything come here. It'll be kept here. No one will have access. The court itself, only the registrar will have a padlock with her 3 keys or 5 keys, whichever number we buy. And everybody else will have a similar number of keys and a padlock. So there'll be no access either way. If you need certain things, it will be actually much easier now for us to deal with what is needed at that time. Okay, on a merit basis. Okay. Mwongela?
Yes, my lord. We are ready to avail those materials as soon as the court is ready with the room and the security.
Even tomorrow?
Even tomorrow, yes, my lord.
Shall we order tomorrow then?
Yes, I'm with my team here, my lord. I'm with my team here. I'm constantly consulting.
Court assistance.
But then, my lord, the seals which are in place be confirmed as the materials.
Yeah, the directions will take into account all the seals that are required, yes. A record of whatever is sealing the ballot boxes, anything that you bring,
yes.
And the serial numbers. The direction will require the registrar to make a record.
Most obliged.
Both at the time of removing them from there and at the time of placing them in our premises. Okay? Just ask the court administrator whether they for tomorrow. Yeah. Send a message to someone. Is this Sylvia? Send Sylvia. So all preserved by-election materials will be held in safe custody by the court. And I'll give an order. I'm just trying to find out whether it can be done even tomorrow. If it can, we'll do it tomorrow. When I looked at the pleadings, I did not see any need for an expert evidence. I didn't see any expert opinions annexed. So I don't think we'll be talking about experts. Will we?
My lord, on our part, we are having a conversation with an expert who, if it turns out positively, may be helpful to the court. So we can make a provision of one expert from our end.
Fourth respondent thinks there might be an expert. Now, the only problem that I'm going to face right away is in terms of mandate. What is the role of the work of the expert? So we'll have to have a discussion during. There's nothing wrong with my recording that. I'm not saying that the expert will be required, but at the appropriate time, we will need to know what is the mandate of that expert, so that the mandate cuts across. Because if you have an expert, I'm sure all the other parties will want an expert, and they have to be dealing with the same question. What happens, I think, in many expert reports is that one goes this way, the other goes in a different direction. They only merge on 1 or 2 points, and the other points become contentious, which means the court will then have to have its own expert to help it understand the two differing positions, and then it can take its discretionary position. Yes, sir.
My lord, maybe I can suggest, in order to help the court, amongst ourselves, we can agree, we can identify the area that needs an expert. So that then the moment we agree we need an expert in KIMS on this area, then we inform the court, then we can have our individual expert speaking to that issue alone, so that the court in advance can get its own expert in that
So
area.
why don't we then pend this matter?
Yeah, so that
Can we
don't
just
have-
pend it?
Yes.
We note that expert may be required, but we just pend it for now. Leave liberty to parties to apply.
Very well.
Is that okay?
Yes.
Does that?
That's in order, my lord.
Okay. Liberty to parties to apply. Item number 9, I don't think there are any other orders. We've been discussing issues as they arise. Even number 10, I think we've dealt with in terms of filings for additional affidavits and so on. We've already given that some directions there. Time management. I'm looking at number 11. The way I do it is that each party gets a block of time. And your block of time is utilized by yourself whenever you're on your feet. So it's like a bank account. That's why we call it time bank. It's like a bank account. If you have 2 days, that's 24. Is that what? 2 days is 24 hours. If you have 24 hours, whenever you're on your feet, you're using your 24 hours. Whether it's on cross-examination or whether it's on examination in chief or re-examination. Or it's an application you are making beyond the applications that we have already decided on. Are we together? Is that, and you will be timed. We will have a clock which the court assistant will keep, and your time will be running down whenever you're on your feet. Okay? So that way we can control so that we don't go too far. I see we have, if we say 15 witnesses each side, you can see we are having about almost 40 witnesses. Okay, we need to control that with the time bank. I'm sure we are all used to the idea that the witness, the evidence of the witness in chief is already given. In the statement, they just adopt it and then we go to cross-examination. Are you familiar with that? So we can do it that way. So that we are basically doing cross-examination and re-examination. That saves time. Anybody who is in principle not agreeable with a time bank arrangement? Petitioner?
Yeah,
Name?
not, my lord. We are okay with that.
Just say your name. I can see a note keeps going round that we are not speaking our names.
They're very innovative.
Yeah.
My name is Gachagua Duta. Yeah, I'm okay with the
Time bank.
yes.
Time bank arrangement. IBC?
Charles Mongela, IBC. We are okay with the time arrangement.
Okay.
Adrian Kamodo for the respondent.
Yeah.
We would be okay with the bank arrangement.
Time bank. Yeah.
But maybe in due course we'll get to know how much is in the bank account.
Yes, we'll give you that. We'll give you that. Once we have fixed the dates for the hearing, we'll agree on the account, the amount to be placed
My
in the
lord, he has
account.
not invited you on the time bank. He has invited you on the bank account issue.
Okay, that one. Actually, I think I have an answer to that one. On the way out, there is an ATM, and there, if you are able to get the correct passwords, you just collect money from the judiciary.
I will pass there.
Okay. And the clock will be kept by the court assistant, and on a daily basis, you remember that the hearing is on a day-to-day basis until completed, and that we are only allowed adjournments for a maximum of 5 days at a go.
Yes, sir.
So we'll try and put, if it takes us, say, a week, we'll try and take the whole week to complete. And if we have to spill over to the following week, there's adequate time. There'll be adequate time. Venue of the hearings, of course, at number 12 is Embu. There's no question about that. The start date of the hearing itself, I think we have to work backwards. The petition was filed on the 22nd of December. So on the 21st of June, there should be a judgment that has been read. So 21st of June, judgment is read. That's the last date. I don't work that way. I don't work on the last date. I try to say if a month before that I could have read the judgment, then it helps me also so that I'm not last minute. So if the judgment is 21st June, can we say 21st May is the date of judgment? Then we can work backwards. We can take a date backwards. So we can take a date in April for hearing. Actually, even before that, we can take a date in March. We can take a date. We don't need to waste, because the applications are all coming within the next 30 days. So we'll have finished the applications. The only issue that might be that might take time is if scrutiny will be allowed, then there will be a process of scrutiny that may take some time. And that could take easily even 2 weeks, depending on the extent to which scrutiny is allowed, if at all. So we need some time in February, March for scrutiny. Ninth of March. Okay. Tuesday, 9th of March? Sorry, that's Monday. It's a Monday. Could we start the hearing on Monday, 9th March?
My Lord, I have a plea in terms of the timing of the hearing.
Yes.
Adrian Kamodo for the fourth respondent. So I'm requesting
Yes.
that if it is agreeable and convenient to the court and to the other parties, we can take a date in April. Reason being, we have slotted the month of March for leaves in our farm.
For leave?
Yes, leave for
Staff.
different staff. And given the magnitude of this matter, it would be crucial that we are able to have a sufficient team over that time, and we would be resuming around April. So April, including myself, I'll be taking some leave around that time. So if I'm able to indulge council, because I also indulge them when they are going on leave, then I'll be glad that we take a date in April.
Don't forget, I'm reading the judgment on 21st of May. Okay, so as you think of the dates, I'll be reading that judgment by or around the 21st of May.
Yes, my Lord, I'm a strong proponent of Article 59. And Mr. Adrian Kamotho, who is my very good friend, that time that he said he'll be on leave, we'll actually be having matters together. For the Supreme Court judges. They are coming that time. So I don't know whether he will stop their leave and come for those ones, or he'll also come and adjourn them. Nonetheless, because of the timelines that are very strict for these petitions, Mr. Kamodo with senior Mr. Gachagua, I mean, there are several advocates involved in this matter. So let us not push the court too close to the end, because it might be as well that there will be a scrutiny, there may be no scrutiny, you know, there are a lot of moving parts. So let us take the earliest date possible before other matters come and take precedence and start clouding our diary. Fortunately, we are here very early in the year, before our diaries become very tight. So if we start 9th of March, maybe we move for a week, then we can adjust something else. But let us take the earliest dates, because you also need to give the court at least a month to do a judgment. So 9th of March would be good for us. Mr. Kamodo, we are together in many matters around that time. So really, let us be here also.
IEBC, let's hear you.
Yes, my Lord, Charles Mongela for first, second, and third. I'm comfortable with an early hearing date because of the magnitude of the witness numbers.
Yeah.
So that we're also able to write the submissions, and you are able to have enough time to write the judgment. So I think my learned friend, with whom we are defending together, may have to sacrifice and come back and hear the matter during that time.
Okay.
Because of the timelines.
Okay. Kamodo, let's start on the 9th of March. If we need to shift some dates, we can still shift them. But let's fix 9th of March as tentative dates, and then if we need to shift, we can do so. When are your people going on leave?
It's generally during the entire month of March, but I will be guided by the court.
Yeah. And let your people know that constitutional duties override their leave. All our leaves. If you want us to work on Saturdays, I can get permission from the CJ. We can work on Saturdays to aid anything that needs to be aided in terms of time.
I appreciate guidance, my Lord, on the imperative nature of constitutional duties. Only that I'm afraid that I might be dragged to the employment court.
Okay. Let's see whether 9th of March can work. That week of 9th of March, let's take that as tentative. Is that week good for us? For I'm talking about
From the 9th to the 12th.
9th to the 12th. 9th to 12th March. Why don't we take 2 weeks and see? What I'm fearing very much myself is the possibility that if there's scrutiny, then that might be a bit more complicated, because sometimes scrutiny raises untidy scenarios that require the deputy registrar to keep coming back to the court for additional directions to deal with a particular sticky issue in scrutiny. I hope that doesn't have to happen, but can we take those 2 weeks? And then they can go on leave from April. In fact, they'll be happier because they'll now go on leave during Easter. When is Easter? We might take a date in Easter. Do you know when is Easter? Let's not take a date in Easter. Okay. Okay, 9th to the 23rd is still available. Okay. So let's take 9th to 12th, and then second week?
And then the schedule will start from 16th to 19th.
19th is a Friday. Yeah. I will not deal Fridays. We'll just take the 4 days of the week: Monday, Tuesday, Wednesday, Thursday. So 9th to 12th is 4 days. 16th to 19th. Is that okay?
That's okay, my Lord.
Thank you. Thank you very much. Item number 15, we've already discussed no adjournments for more than 5 days in at a row. Now, perhaps when we are doing the applications, I'll give further directions on the hearing, particularly because all the parties' documents will now be in place and their witness statements we'll be in a better place to give clear directions with regard to the hearing. So can we skip number 16, the hearing program? But generally have it in mind that we will be starting at 9 o'clock. We will go to a health break at around 10:45. We will reconvene at 11, go to lunch break at around 1, and then end at 3:45. 3:45.
After resuming at 2.
At 2. We resume at 2, sorry. We resume at 2 and then end at 3:45. Okay. That's how the program will be. Okay. I'll detail it out. We'll flesh it out a little more when we come together. Actually, I do have it here. Just pass this to the council. That will give you guidance that by the time we come for the hearing, it will be just a question of now fitting in numbers. Just fit in the numbers. Can we jump to item number 16 now? That's a hearing on costs. I prefer to have a formal hearing on costs at the end of the hearing. So each party has to assume that they have won the case, and so you make your submissions on costs. And then when the outcome comes out, of course, then I'll be able to deal with the costs based on the information that you will have supplied through your submissions on costs. So there will be a hearing on costs. The date of that, of course, is not known. We'll talk about that. You are used to written submissions on a hearing, so that's what we will do. We will not depart from that. I'm looking at item number 18. You may want to highlight, most probably, because it's a big petition. I'm sure you'll want to highlight. We'll give room for that. I will make some directions on the money that has been deposited. We have the 500,000 shillings that has been paid in by the petitioner. So there will be directions on that at the conclusion of the hearing. Sorry, not at the conclusion of judgment. Item number 20, we've already fixed the dates. The directions emanating from the pretrial. I'm looking at item number 21. Hopefully we'll be able to get them to you either tomorrow, at the latest on Monday, because you can see it's a long mention pretrial that we've had. So on Monday at the very latest, we'll be able to give you the directions emanating from today. Parties are still free to settle. I'm looking at number 22. Yes, Article 159. And the court's role in promoting ADR.
Yes, we have actually extended an olive branch to Mr. Wamuthende.
Okay.
And then we want to receive Adrian Kamodo for the further respondent, because counsel for the petitioner has indicated that extending an olive had, we receive it with gratitude, and I think we look forward to their withdrawal of the petition.
My lord, he's putting words in my mouth. My name is Dewa. The Olive Branch, we're inviting it for him to concede the petition.
Okay. All right. At any rate, I'm required to let the parties know that that opening is still there, that the Article 159 requires the court to promote alternative dispute resolution mechanisms. So I've done that. If the parties are able to settle, let me know, and then there's an application that has to be done for settlement and withdrawal of the petition. That's item number 22. Item number 23 talks about the certificate as to validity of the election. That will come after the judgment. Yes, sir.
My Lord, Karuthui for the petitioner.
Yes.
With regard to number 22.
Yes.
And with regard to petition number 1, we would wish to ask the court to grant the parties a few minutes, probably after this, to have a conversation with regard to petition number 1.
Yes.
And then we can probably come back and record our consent if we manage
Yeah.
to agree.
We decided that we are dealing with petition number 2, and we pended the item on the consolidation, correct? In petition number 1. So I will definitely grant some time. There's nothing to fight about. If parties are able to resolve any issue in their own way, let them resolve, and then I'll deal with it. Item number 23 and 24, these are the statutory certificates or reports regarding the outcome of the petition. And that certificate as to validity of the election will be issued as and when, depending on the outcome, and a report of the court as to whether there were electoral malpractices may have been committed. That will also be part of the process. I think we've reached the end. Is there any other business other than the question of the consolidation? Is there anything you think we have left out that needs to be taken into account? Yes?
For the petitioner, there's nothing.
There's nothing?
Yeah. My name is Kiragwa Duta.
Okay. For first?
Yes, Mongela for the first, second, and third. Nothing has been left out, my Lord.
Thank you. Fourth?
My Lord, Adrian Kamodo for the fourth petitioner, for the fourth respondent. There is an issue we would like to get clarity about in terms of the form of the petition, because it has been filed as a constitutional and human rights petition, and ideally it is supposed to be an election petition, since it's challenging the outcome of an electoral process.
Yeah.
So, because there's a distinction between when a matter is filed as a human rights petition and when it's an electoral petition.
Yeah.
So it looks like there's a hybrid kind of a petition in terms of the way it is styled.
Yeah.
Maybe we can get clarity on that.
Yeah. The only thing I can say is this. The party who filed it under this head. We no longer even have control as to how parties file. But court assistant, this is filed as a constitutional, I noticed that it's filed as a constitutional and human rights petition. Election petition. Is there such a...
It is number 1, my Lord.
Sorry?
Petition number 1 was filed as a constitutional petition.
Yeah.
Because this court had not been gazetted as an election court then.
Oh, I see.
And the tab for election court was inactive.
Okay.
So we filed it
Okay.
on this side, but then we wrote a letter
Okay.
to have the Chief Justice gazette the election court.
In any event, since my appointment as the election court, I am treating it as an election petition unless parties choose otherwise. But I think that explanation probably covers it. Are we okay with this? To me, it is an election petition, not a constitutional and human rights petition.
My Lord, Adrian for the fourth.
Yes.
Even the second petition, because this is the second one, E002, it also carries the name, the same nomenclature of High Court Constitutional and Human Rights Election Petition. So it's a hybrid of human rights, EP.
I am not going to treat it that way, even if that's what they have done. The truth is that there were 2 appointments. Every election petition has to be directed to an election court. When the first petition was filed, I was appointed, I think, in December as an election court. This court was appointed as the election court in December for that petition. The second petition had not been filed then. When the second one was filed, I think I was nominated on which date? Was it the 2nd of January? 2nd of January. And so there are two Gazette notices, if you check. There are actually 2 Gazette notices identifying this court as an election court. One for each petition. So if anybody is treating this as a human rights petition, I think you are in the wrong court. Yeah. Yes?
Yeah, my lord, maybe just to add to what you say, just in the neighboring Kirinyaga here in 2020, I think 2017, constitutional petitions, election petition camouflaged as a constitutional petition. The court converted it. In fact, the Chief Justice gazetted it as an election petition. So I think that answers.
We've always done that.
Yes, ma'am.
The very first petition filed in Nairobi for the governor was filed as a constitutional petition, and I converted it into an election petition. So there's nothing to worry. This is not a constitutional and human rights matter. It's a matter under the Elections Act. So that's how we'll treat it. Is that okay?
That is satisfactory, my lord.
Thank you. That was Mr. Kamoto. That's for the fourth petitioner.
Correct. Fourth respondent.
Fourth respondent. Thank you. I think I need that blue piece of paper. saying respondent. Because I keep saying petitioner. Yes, sir.
My lord, this is Gachagua for the fourth respondent.
Yes.
Seeking further clarification on the point that my friend Dr. Kamodo has raised.
On whether this is a constitutional petition.
Yes, my lord. That question is coming because when we started, you did mention that constitutional petitions do not attract costs.
Yeah.
But I am aware that election petitions do attract costs.
And we've dealt with it.
Yeah, so that's why we need that clarification, because we will be keen on costs.
Oh, definitely.
Yes.
You will even be submitting on costs. We've dealt with that, isn't it? We've dealt with that on where did we deal with costs?
Item 17, my lord.
17. Yeah, item number 17, hearing on costs. Every election petition, in fact, a deposit has already been made. So money will be spent by someone, one way or the other. Okay, so it is not a constitutional petition. I was just saying, for purposes of comparison, constitutional petitions do not carry costs generally, and that's a rule of thumb for the courts, or a rule of practice. I think it should change. Myself, in a different context. So is there anything else that we need to deal with in this petition? Because I want us to take a break now, so that everybody's health is better, and give you 5 minutes also to deal with the consolidation question, and then we come back for petition number 1. Is that okay?
Yes.
We come back for petition number 1 and to conclude the consolidation question in petition number 2.
Yeah. Your Lordship, and
Thank you for that guidance. My name is Gachagua.
perhaps the issue of petition number 1, because we may need to make more consultations. Very well. You can take that break.
You can take a break.
Yes.
Okay, so we are journeying for, do you want to go for lunch?
No, just a few minutes. 10 minutes only.
10 minutes.
It's agreeable.
10 minutes? 10.
With them together. And my Lord, we have more or less aligned substantially, but our request is that you give us some bit of more time to resolve that issue and report to you latest on the day we are coming or 12th of February 2026.
12th February.
12th, yes, 12th of February, when we will be coming for hearing of applications, so that we can conclude that issue once and for all. We note that by that time, all pleadings in petition number 1 will be on record, so that then we can take a definitive position. But what we assure you is that that will not alter the order of the timetable for the hearing of petition number 01. There's just one bit which we need to align with my learned friends, Mr. Kamotho, Mr. Kashufa, and Mr. Mwongela. Just one item which will resolve my Lord.
Okay.
Yeah.
Let's hear
Thank you.
from IEBC.
My Lord, in this one, Charles Mwongela for this one I appear for the second and third respondents. My Lord, it is true the petitioner has talked to us and asked us whether our clients could concede the issue of costs if they were to withdraw the petition, and I told them our position remains that costs will be pursued by the Commission, the IBC. On the question of consolidation, my Lord, again, we are not in agreement with what the petitioner is suggesting. My Lord, we filed our response to E001 within the timelines, and having found the petition to be non-compliant, my Lord, we filed an application to strike out as per, and directions were given. We served. It was responded to through grounds of opposition. Submissions have been filed on it. So, my Lord, number one, you can the question of consolidation cannot the two petitions cannot be consolidated because E001 was dead on arrival. It was a non-compliant petition. It cannot life cannot be breathed into E001 by subsuming it under the rubric of E002. E001 was dead. So for us, we are completely opposed to consolidation. Number two, we'll be pursuing the question of costs before you will be submitting on costs. Thank you, my Lord.
Lord, Kashuba for the first.
It's fast.
Yes, it's first in this one.
You are fast in this one.
Yes.
Yeah.
My Lord, on our part,
Yes.
number one will be pursuing costs. We have filed a response to the petition. We also filed 2 applications.
2 applications.
Yes, my Lord.
On what?
On the issue of deposit and also on the issue of jurisdiction.
And the issue of
Jurisdiction,
jurisdiction.
yes,
2 applications, one on deposit.
yes, and the other on jurisdiction of the court.
Yeah.
My Lord, we also
consolidated because E001 was dead on arrival. It was an uncompliant petition. It cannot, life cannot be breathed into E001 by subsuming it under the rubric of E002. E001 was dead. So for us, we are completely opposed to consolidation. Number 2, we'll be pursuing the question of costs before you will be submitting on costs. Thank you, my Lord.
For
My Lord, Gachagua for
Fourth.
the first.
it's first.
Yes, it's first in this one.
You are first in this one.
Yes.
Yeah.
My Lord, on our part,
Yes.
number 1 will be pursuing costs. We have filed a response to the petition. We also filed 2 applications.
2 applications.
Yes, my Lord.
On what?
On the issue of deposit and also on the issue of jurisdiction.
And the issue of
Jurisdiction,
jurisdiction.
yes,
2 applications, one on deposit.
yes, and the other on jurisdiction of the court.
Yeah.
My Lord, we are also opposed to the consolidation
Mm.
with the petition 2. Because, my Lord, as far as the law is concerned, petition 1 cannot be heard as it is. So there's
Petition 1
nothing-
cannot be heard.
Yes. So, my Lord, we oppose the prayer for consolidation.
Okay.
That's all.
My Lord, just to point out some additional. Adrian Kamodo for the 4th respondent. Oh, this is sorry. This one for the 1st. It is clear in law, and it has been buttressed by the court severally, that the requirement for security deposit for costs is mandatory, such that a petition will only be deemed to be properly lodged if and only if the deposit for the security deposit has been made, and it must be made within not more than 10 days from the time of filing, such that any failure to comply becomes incurable in any manner. Now, there are consequences that are prescribed in law at Section 78 of the Elections Act for the failure to provide security for costs. And it is categorical in nature that if a petitioner does not deposit security, no further proceedings shall be heard on the petition, and the respondent may apply to the election court for an order to dismiss the petition and for the payment of the respondent costs. We have in compliance with this provision, apply to strike out this petition, and we are also applying for payment of costs. My Lord, when this petition was served upon us, it was over the festive season over Christmas. We had to curtail all our plans and invest because according to such petitions.
Council, if you don't mind, you are now arguing on costs. You made the statement that you are going to be seeking costs, correct?
Yes, we shall be seeking costs.
You'll be seeking costs.
Yes.
Let's leave it at that. Let me hear if there's any response from this side, because they haven't filed submissions to your application. Let me hear whether there's a response.
Yeah, Your Lordship, and my name is Gachagua Duta, and we were avoiding to delve into this because we thought we would save more judicial time by dealing with petition number 02. My Lord, when petition number 01 was filed, there was no election court. And it was properly characterized as an election petition on access to justice. So that even the issue of costs will not arise. In any case, and these are things we are raising in our crowd, for any money to be paid to the judiciary raises an invoice. There is no invoice for cost which has ever been raised because it is a constitutional petition. If you look at petition number 02, an invoice was raised.
01 is a constitutional petition.
It's a constitutional petition. Well, when the court was gazetted to deal with it then it did not change the character. So that's why we said, let us go. Mr. Kamoto said, is it a constitutional petition or is it an election petition? So those are the things we said. As council, those are things we can resolve behind the tent. We come before the court and address the substantive matters that are now before the court. Okay. So if you may just give us up to that date, we will consult on all those things, align as we do even the trial battles. Then we come and tell you, Judge, here we are, hear us on these matters. Otherwise, we'll go on and on whether it's an election petition, constitutional petition, whether the court has raised an invoice for the payment, because the petitioners could not have defaulted if the judiciary never raised an invoice, as it did in number 02. So really, just allow us time to go to consult. And Mr. Kamoto, we can agree with him. Mr. Kashufa, definitely. Mr. Mongela, even easier. So just give us those days.
My Lord, just to weigh in on that issue, my name is Dewanjiro. The application that the first respondent is addressing you on, the one that is dated the 27th of December 2025, my Lord, at paragraph 9, they have challenged your jurisdiction insofar as entertaining this petition is an issue. At that paragraph, they say that the court lacks jurisdiction to entertain this petition, and the argument is that this ought to have gone to another arena. So perhaps even before you address the question of cost, I find it sound to address the question of jurisdiction, so that then the outcome of the question of jurisdiction will follow, the question of cost will follow the outcome of this allegation that you have no jurisdiction. And then you'll also be able to square out in terms of Mr. Kirago's submissions. At that paragraph, they say that this matter ought to have been filed at the political parties' tribunal. So, my Lord, perhaps time would be of essence to also allow us to respond to this application. It's raising very weighty issue of jurisdiction.
Which one is that, the application?
Is the application by the first respondent.
What's the date?
27th of December 2025.
Yeah, but I think we dealt with that, isn't it?
Did we?
Let me give my directions. I don't want us to go round and round in circles on this. My directions are very straightforward. One, the parties are granted 7 days within which to file a settlement. 2, filing of a settlement, the court shall rule on the pending applications. I think there were 2 of them, on which submissions have already been filed. Issue as to costs will be addressed in the ruling. Right? So we finished with that. The matter will not be consolidated for now. It remains a pending question, in which case I don't think we need to discuss petition number 1 anymore. All right?
My Lord, just an addition to your proceedings, Gachagua Duta, maybe we can be allowed to file our submissions within those days.
Council are not allowed.
Very well.
I think you have been dilatory.
Very
There
well.
are directions. I'll
Very
not
well.
allow.
Very well, my Lord.
I'll not allow. I'll go with what is on record right now.
Very well.
You have been dilatory.
Very well.
You should have filed submissions, and then you can come for, if you want additional submissions because there's a new application or whatever, I would have allowed that. But for this, it was quite clear. It came early, and there was a lot of time.
Very well, my Lord.
Yeah.
But there are 2 applications on the same issue.
The one on which I gave orders.
Okay, very well.
The application on which I gave orders, which seeks to strike out,
Yes.
that is the application which I will be dealing with.
There are 2.
If the one which I gave orders on filing of submissions.
Oh, very well.
If there are 2, then responses are also required.
Okay, very well.
Okay? So where I had already given orders,
Yes.
I can't just let me have this file.
It's okay, my Lord. I understand. I understand.
It's on our application, my Lord, of 29th December.
So my Lord, to assist the court, there is one dated 22nd December 2025. It's an order issued by the court.
Certificate of, oh, this is number 2. Why is number 2 filed in here? This is the certificate of urgency number 2 in petition number 1. And it has the directions in here. Okay, that's the one I'll be dealing with.
My Lord, there is also the one dated 19th
Did I give directions on it?
19th, yes, you had given directions. The one that came up before the court on 19th December 2025, the court gave directions on 22nd December 2025.
Okay. This is petition 1 still.
Petition 1 still.
I can see directions given on 31st December for submissions. I can see directions given on 19th December. Those are the ones I am seeing for submissions in petition
Yes,
number
correct.
1.
Correct, my Lord.
Yeah. Okay. In petition number 1,
Yes.
there are 3 sets of directions I have given.
Yes, yes, my Lord.
I give directions on 8th of December.
Yes.
I give directions on
31st.
19th December. And I give directions on 31st December.
31st December.
Yeah. So that's what I'll be dealing with.
Okay, very well.
Yeah. Okay, so I think we are done with the.
Yes, my Lord. Yes, just some directions. I know we undertook to that materials are in the my Lord.
Yeah, I'm going to deal with that. Just give me a couple of minutes. I'm drafting it. I had started drafting it, and I needed the legal researcher to be by my side, it's what we are looking at. So if you give me about 20 minutes
Change the dates
to change,
from tomorrow
Yeah.
to Monday. My
I
team
thought
is
you said,
going to Naivasha.
I thought you undertook to do it on tomorrow.
Yes.
The reason I don't want it to be on a Monday
Yes.
is Mondays are busy days.
Okay.
Monday, Tuesday up to Thursday. Fridays are quiet days in the court. So I don't want all this 190, everybody to be all over the place.
What about Tuesday, my lord? They are going to Naivasha this afternoon.
Hmm?
My team is going to Naivasha this afternoon for another scheduled IBC activity.
Mm.
Yeah.
It's just that you promised me that you are available even tomorrow. Now you are changing your mind.
Initially, they told me even this afternoon. Then they told me they are traveling.
Who told you that? Is it the lady behind you? She bears responsibility. Maybe she might have to.
Yeah, give them until Monday, my lord. The other issue is the lorries.
Yourselves. You will carry the cost of bringing the materials. All that is in the order. All that is in the order.
Let's wait for the orders, but kindly, my lord, if you can have it even on Tuesday. Tomorrow is proving a bit difficult. I gave the undertaking, yes, but I kindly want you to vary it.
Okay. Any problem, counsel?
Yeah, my lord, there's a reason why those materials should be kept safely. And
No, any problem with extending to Tuesday?
change of heart does not very comfortable. Let them be brought tomorrow. It's just loading and offloading. I mean, the people.
No. It's not just loading and offloading. There are serious directions that the DR will carry with her. It includes taking an inventory when they are at the station where they are kept currently. It requires the removal and placing in our secure room.
Yes.
And another record be made when they are secured there.
Yeah.
So it's quite a bit of work.
Yes, my lord.
And it includes that each party will be allowed 2 persons to be present.
My lord.
To be present for that exercise.
We have even made accommodation arrangements. We changed our schedule immediately. We are staying here in Embu today because we need to be here tomorrow. They can equally change with these exercises. If we are going to Naivasha today, the training is tomorrow, or whatever it is tomorrow. So let us accommodate each other.
Okay, that's your position. What's your position, counsel?
Well, I'm slightly taken aback by Mr. Waduta because since morning, counsel have been very accommodative. Even when his clients were not present and he said they were within the compound, we still tolerated him. But now a request has come and he doesn't want to budge. For us, we are willing to accommodate because we believe what has been stated is reasonable. If there was a pre-scheduled event, which may be out of inadvertence, was not pointed out initially, and now it has been confirmed, it's only fair that we allow them to carry on with the rest of the programs, because you know the area is also subject to other by-elections, which are ongoing. Maybe it's part of it, I don't know, but I don't think the world will come to an end over the weekend if we give them up to next week.
Dego and Jiro.
Yes, my lord.
You are usually very vocal.
My lord, my lord, considering that this election took place on the 27th of November and these materials have been in the IBC, I would urge my colleagues to concede. In any case, should anything happen to the materials, the court is there to see. There is not, London will not ban. We can accommodate them, my lord.
Okay. Waduta, have you reconsidered your position?
Yes, I've found my Saul Paul moment. I concede also to that request.
If we continue like this petition will end next week. Okay, thank you very much.
Thank you.
So the order will be for Tuesday. It will be for Tuesday, so that also gives me a little bit more time to craft it. So it will probably be uploaded because you will not be here now, but I think it will be uploaded before the end of the day. All right, but it's for Tuesday.
But my lord, our magnanimous should come at a cost that the senior should be able to take care of our lunch today.
I think that IBC is it's a people's body, isn't it?
Yes.
You are a state corporation. No, you are commission. You are commission. I'm not going to give any directions. But you've heard the plea of the people.
And they have a provision for hospitality.
Oh, really? Okay, that's not before me, obviously. And I didn't see it in the petition or in the responses. Yeah, okay. So is there anything else that we haven't dealt with? Okay. So, yes, Council.
I believe